Welcome back to the conversation on News Central Television. Moving out to Kenya, where members of the Azimio La Umoja political alliance are calling for change in the law regarding Friday arrests. They argue that arrests made on Fridays should be outlawed unless there are exceptional circumstances, and individuals should have access to police bail. This move is in response to what they perceive as the weaponization of the criminal justice system, as they claim that weekend arrests have been used to frustrate political leaders and government critics. They also advocate for civil process of arresting MPs through the office of the Speaker, with a notice issued before any arrest can be made to ensure that members of Parliament are not treated like common criminals. Now, joining me this evening for this discussion is Ken Echesa, an advocate of the High Court of Gbenga. A warm welcome to you, Mr. Echesa, and thanks for joining us on the program.
Thank you very much. It is indeed the position of Azimio La Umoja One Kenya Alliance in Kenya that members of Parliament, the legislators, should not be arrested on Friday evening because government have abused this privilege in the Constitution to harass, blackmail, and intimidate the opposition.
Now, Mr. Barrister Echesa, let's just roll back a bit and let's start from the reason behind this decision or this statement by the lawmakers. Could you elaborate on the specific instances where the criminal justice system has been weaponized through Friday arrest as alleged by the Azimio La Umoja lawmakers? Or why are they asking for the government to stop, or law enforcement agents should stop Friday arrest?
They are asking the government to stop Friday arrest because in the past and during the opposition demonstration, about 4 members of parliament in the opposition were arrested on Fridays. And the reason why government arrests opposition legislators on Fridays is because the law, Kenyan criminal law, allows the police to hold suspects of crime for more than 24 hours if the next day is falling on either a weekend or a national holiday. So you will get government agencies and the police arresting Kenyan legislators in the opposition on Friday and arraigning them in court on Monday. Sadly, they even did not charge them on that particular next court day, but they ask for more days to hold them in the name of doing investigations. It is this weaponization of the criminal justice system that the opposition leaders of Azimio La Umoja One Kenya have now asked government to consider changing or amending our criminal statute and exempting the Friday arrest, since they are being used politically to achieve the political end.
Have Friday arrests historically been used to hinder the political agendas of leaders, and are there examples of this happening in recent times? You did mention the issue of the demonstrations that happened recently, the cost of living demonstrations. What challenges and logistical complexities might be involved in keeping courts open until midnight on Fridays to process bail for individuals who've been arrested?
Thank you. The arrest on Fridays in a Kenyan context is historical. This has been happening since the days of the founding father of our Kenyan nation, Mzee Jomo Kenyatta, into the Moi administration, into the Kibaki administration, into the Uhuru administration, and now is the current regime of the President Dr. William Ruto. The problem, the logistical problem with this arrest is that our weekends are not working days for the court. But we have a window in the judiciary. If the Chief Justice, in addressing these injustices meted against Kenyan legislators, can gazette weekends and holidays as working days for the court, and perhaps have duty magistrates and duty judges to handle cases involving politicians who are arrested outside court working days. This will save. However, it will need an increase in the budget allocated to judiciary for working outside court working hours will require an extra expense from the judiciary expenditure.
Explain the potential advantages and disadvantages of having the Speaker's office involved in the process of arresting members of Parliament, and how may this impact the separation of powers in Gbenga? I mean, is it not interfering in the work of law enforcement and the executive? And are lawmakers so special or above the law that you might require the consent of the Speaker of Parliament before you can arrest a lawmaker? What do you make of this?
Thank you. The major advantage of law or an arrangement, logistical arrangement that would bar arrest of opposition legislators or members of parliament for that matter over the weekend is that we de-weaponize, we prevent the abuse of a criminal process to achieve political ends. This will serve greater justice and make parliament more freer and objective in their criticism of government. But with the fear of arrest, members are likely to shy away. And the greatest disadvantage is that there could be a potential abuse of this privilege, with members of parliament getting involved in criminal acts and criminality and hiding under the law that they cannot be arrested over the weekend or outside the court working hours. There therefore needs to be a balance between the rights and privileges of members of parliament and also the rights and privileges of the members of the public. Members of parliament in Kenya, just like in any other common law jurisdiction, are special in a way and also ordinary in a way. They are special in a way because they are the people's representative. The people have chosen them. And since they are the people's representative, they need to be treated in a better manner compared to the person who has delegated that authority to them. If you muzzle them, if you intimidate them, if you blackmail them, by extension, you are blackmailing the entire people's representative and the entire region that they represent. Either way, they are not very special to be exposed to privileges that they are bound to abuse, because the representative cannot claim to be treated better than the elector or the represented. And when you allow the judiciary to give special treatment and privileges to the member of parliament, you are interfering with the doctrine of the separation of powers. Ideally, there needs to be separation of powers between the executive and the legislature. However, there can be a logistical arrangement that can still be relevant and obey the laws on the separation of powers by allowing interdependence of the organs of parliament or organs of government.
Now, Ken Echesa, in the context of the proposed audit of cases related to MPs and Azimio supporters, what criteria should be used to determine which cases should be dropped and what precedents exist for such actions in Kenya's legal history?
What should be done is that, you see, government has a monopoly over all instruments of violence. Government has a monopoly over all instruments of power. When a government-affiliated legislator is arrested, he is bound to be treated in a normal way, like a normal suspect. But the criteria should be, whenever a legislator from the opposition is arrested on a suspected crime which borders politics, like demonstrations, like abuse of freedom of speech, in which speech is said to have criticized government, there ought to be a pretrial by an independent arbiter like a magistrate, because a judge will be of a higher level, a magistrate of a lower court, to determine whether the accusation stand a chance to be tried in a court of law, or to give a nod for holding of such ranking member of a society. This is what in a civil case we'll call the grant of an injunction is based on whether we have established a prima facie case. We can import this thinking in our criminal justice system and say whenever a politician of a certain rank is arrested, like a member of parliament, especially from the opposition, we should be having a pre-trial conference by a magistrate of a lower court, to establish if there are triable issues, if the prosecution or the police have established a prima facie case to warrant the retaining of these members of parliament in a cell before arraignment in court. Historically, the opposition has been harassed in Kenya, in East Africa, and in Africa over years. It is a remedy that would ensure some safeguards and guarantee the observation of rights by government against the officials, the leaders of the opposition, and the members of parliament allied to the opposition in Kenya and Africa in general.
Echesa, I'm happy you started your submission on this question with the government has monopoly over the instruments of violence and enforcement. Now, what legal avenues are available to ordinary Kenyans to hold authorities accountable for violating the established arrest rules, including the denial of medical assistance as claimed by these Azimio lawmakers?
First, we have several remedies guaranteed under our constitution. The first one, every Kenyan, including members of parliament, have a right to apply for an anticipatory bail. Anticipatory bail is that bail you are given by court in anticipation of an unlawful arrest. If a Kenyan politician feels that the government is pursuing them because of political reasons and they do not know when they could be arrested, they can approach the High Court of Kenya for the grant of an anticipatory bail. Once you have the anticipatory bail, the police cannot arrest you. They can only ask you to appear in court on your own volition at the time that they will appoint. If you don't appear in court, then that anticipatory bail will be withdrawn and you will be arrested. The second remedy, which is a remedy that we have borrowed from the common law, is that of suing government and the Attorney General for compensation for malicious arrest and malicious prosecution. If you are arrested and prosecuted in a manner that is malicious, a manner that does not comply with the Kenyan law, you can sue the Attorney General, you can sue the government for compensation. And we have seen ordinary citizens being compensated in terms of millions of Kenyan shillings. And lastly, number three, is that our constitution, the Kenyan constitution, allows and guarantees the protection of the right under the Bill of Rights. If you've been arrested, if you've been charged on politically trapped up charges, you can approach the High Court and sue for violation of our constitutional rights, and then the court will order that you be compensated. Those are the remedies so far in our legal structure.
Now, Ken, as we begin to wrap up this conversation, what specific measures or legal reforms could be introduced to ensure that arrests, especially of high-profile individuals, do not violate the 24-hour rule as outlined by Justice George Odunga?
Very well. Justice George Odunga has been very, very progressive in turning out jurisprudence that speaks to the protection of fundamental rights and freedom of the people of Kenya. One of the clear safeguards that the people of Kenya must think of now is to amend our criminal statute to state that if an ordinary Kenyan or a member of parliament is arrested on a Friday or a day preceding a day which is not the ordinary court day, such a person must be released on cash bail. And the wording of the statute must be quoted in mandatory terms that any person arrested on a day which precedes a day that is not ordinarily a court day shall be released on reasonable cash bail and shall not, at whatever cost, be put in custody until the next day. This will save the ordinary Kenyans from the abuse of their rights and freedoms. In any event, why should the police not arrest one between Monday and Thursday, only to wait for a Friday to arrest you, knowing that you cannot be presented in court on Saturday? Secondly, we can have a law reform where before an arrest is made, the suspects collect statements and an arrest is made based on the statements of the complainant. And at the time of the arrest, the police must ensure that they have established cogent evidence against the person they are arresting, and that once you are arrested, it will not take more than 6 hours in court so that you are arraigned in court. For that matter, we can also have the Chief Justice be allowed to gazette weekends and holidays as special sitting days for the court, especially for the offenses that are risky in nature, offenses that are grievous in nature, where the magistrates and judges can sit on ad hoc basis over the weekends and on duty roster to take care of such very grievous offenses, which we suppose will not be many.
Thank you so much, Ken Echesa, Advocate of High Court of Kenya. Do really appreciate your insight and contribution to the program. Thanks for giving us the context. We do appreciate your candor. Thank you.
Thank you very much, and thank you for hosting me.
You're welcome. Look forward to engaging in the nearest future. And that's all on The Conversation. Today, in the first half, we did look at the new EFCC chairman's appointment, which has sparked controversy in some quarters. A number of people are saying he doesn't meet the requisite 15-year cognate experience as stipulated in the EFCC Act, which has concluded a conversation on the opposition lawmakers in Kenya saying the government is weaponizing Friday arrest and they seek to address that situation. I'm Gbenga, Aborowa. Thank you, as always, for being a part of the conversation. See you on Monday at another edition of The Conversation. Bye-bye.